The presentations I've done so far in recent weeks have been on the basic information every attorney needs to get from their clients, which is information which is generally important when engaged in litigation or in drafting of documents. I've also looked at money laundering legislation and what attorneys do to comply with that, in particular what is known as FICA. This specific presentation is an overview of what, depending on response, will likely be a series of videos or presentations on the sort of information that an attorney should have in mind when they are interviewing a client. Unlike the video presentation on the vital information an attorney has to get, we are not talking about information about contact details or basic things about status or marital status and so forth. We're looking more into the content of information which an attorney should try to get. The specific backbone of what I'm doing is an information sort of checklist of questions which I've developed over the years. Its original form, I think, was about 5 years ago. So every now and then I'll create a new form of it, and it has all of those sort of questions of things which I look into. I don't genuinely ask question by question the information which I have in it from my clients. I will listen to my client's story. I will extensively cross-examine them about what's happening in their matter. And then, if there's additional information I feel I need, this sort of checklist, whether in my mind, as it often is, or having it on my computer in front of me, is quite useful, as I'll go into that specific area and I will start asking the client the sort of questions involved. The wording which I've developed in my own form is quite complex wording, in the sense that for each question, I'm probably looking at 5 or 10 different questions if I were to look at it more simply. And so with the specific presentations, I plan to give my complex language, but then explain exactly what I'm actually saying and asking of clients, because I don't generally ask in the complex language. I use my own language with my clients. Firstly, I'm going to give a general overview in this specific presentation of the sorts of things which I'll be looking at. You'd be looking at the people involved in the matter, including your client. The attorney-client relationship is quite important, and the relationship a client has had with previous attorneys is also very important, as it can really affect how things go forward. Prescription is the thing which destroys matters. If an attorney is being sued for negligence, it's usually because they let a matter prescribe. And prescription is the idea that after a certain amount of time, a matter should no longer be brought before court, and if it is, it should not necessarily succeed if the other party raises prescription. So one of the first things I'd look at with a matter, if prescription is possibly going to apply, is all of the different things involved with the prescription. And I'll go into some detail in that if I do land up making the series of videos on this. So prescription, you'd look at the ways of determining it, and within that, the effect of prescription, what it does for that specific matter, what data is involved and how it affects that. You look at whether there's ordinary prescription applying, and whether there are exceptions, whether there are things which have delayed prescription, and anything that might have interrupted prescription. Within prescription, I usually also look at dealing with organs of state, because you need to do specific types of notice to organs of state in a very small amount of time after problems have emerged. So notice to the state of proceedings against the state, it's something you'd look into. You look at whether or not it's a state organ which is involved, and notice and condemnation for late notice. The next thing which is quite important to look into is the status of the parties. You often need to know, does someone have locus standi, which means do they have place to stand at court? And essentially, if they don't have it, then you have a problem. And you also have a problem sometimes when you're suing someone or when someone's involved in a matter and they don't actually have capacity to do what they're supposed to be doing. So you look at vulnerable persons, which is a phrase which often is involved in evictions and certain other matters, and persons represented by others. You look into insurance, guardianship, etc., and you look at subrogation, which means the stepping into the shoes of another person, which particularly in insurance law often occurs. You look at whether or not parties involved have sufficient interest in the matter to be deemed to be allowed to deal with it at court, and so forth. You look at courts, adjudicators, and jurisdiction. And a matter might not, in fact, be something which can be brought before a South African court, or there might be other things which have to be dealt with first. So that's quite important to have in mind when dealing with a matter. You then look at the matter itself, not in great detail at this stage. You look at it a bit later in quite a bit of detail. Then you look at the urgency and permanency involved in the matter. So is something urgent, and is the effect of what's happening likely to be permanent? And if it is permanent, what is the result going to be? You then look into the circumstances of the acts involved. That's the cause of dispute or potential dispute, knowledge, seeming authority, and interactions involved. You then look into the essential acts which are involved in the matter. That's your type of actions, the weight of the actions, primary actors involved, benefits, and losses. You then look whether or not there's a duty to act or refrain from action. That's quite important, as if someone doesn't have a duty to act in a certain way, it might very well affect how things go in the future. And you might want to create a duty to act in a certain way as well. The locations involved are quite important in a matter. There are famous examples of the specific location where something is alleged to occur or is planned to occur actually has a complete and utter effect on the outcome of a matter. And it's also important to know the locale of where something is occurring. Then the surroundings, money and objects involved. So you look into a lot more detail of objects and surroundings and money and monetary amounts and claims which might be involved. Then the facts and the parties' various cases. I find that it can be incredibly awkward where you're dealing with a legal matter, you phone up the opponent in the matter and you start talking to them and they start pushing out a completely opposite story of what your client has told you. So it can be very important to talk to your primary source on things, which is your own client, and to find out how they think that the other people involved in the matter will see it. And if they're lying about the matter to your client or to you, it's good to be prepared for what lies they might bring up. And other people's cases and ideas are very important to be able to discuss with your client. The facts and the parties' various cases. Okay, so factual basis and legal basis of party interactions is also another important thing to look into. And the party interactions and the relationships between the parties are quite important as well. Then trust and verification. There's a famous saying, and I think that Ronald Reagan is quite famous for it, which is trust but verify. And so it's important to look at what type of trust relationship the parties have. Is the trust necessary? And what type of verification of things can take place. Then the background, financial positions, and environment things are taking place in. Financial positions can be quite important in a matter, and financial history of the parties can actually be something which directly needs to be dealt with. Underlying causes of what's occurring is quite important as well. Remember that something like 90% of cases get settled out of court. So if you can find out what the causes of things are, it can be quite important to your overall goal of getting your client what they want or something which they could live with. Then witnesses and evidence, documents and evidence, dishonesty, clues, cues, and indirect communications, fairness, rights, risks, and circumstances. And within that, you're looking at fairness and so-called good morals of society, which is a legal phrase. Risk management, rights, and circumstances. Justified differentiation, where there is some sort of discrimination. And fundamental rights and general ideas of rights. And where you look at the sort of general ideas of rights, it can be quite useful because it can spark something in relation to the matter and cause further discussion into important details. Then you look into leaks, reports, reputation, and the spread of information. One of the strange things which you might not realize is that certain matters will turn based on when a party first spoke about it to someone else, particularly in certain types of crime. And where information might spread, it might also be counterproductive for a client to pursue a matter in court. And you need to be able to deal with the spread of information in a matter and how it affects your client's reputation, as certain approaches are not appropriate if your client's reputation can be affected. And as I've said before, when I've dealt with domestic violence matters with clients, you often find that someone who is accused of domestic violence gets fired from their job. So the mere accusation, if it comes to light that there's an accusation or a court case involving that, can have very bad effects on someone. And the same goes for other types of litigation or legal matters. So it's quite important to look into that. Then analysis of the facts and law and other factors. And finally, you create an overall plan of action. And that includes protocols for contacting other parties. How do you go about it? Negotiation, what your negotiation plan is. Alternative dispute resolution, that includes possibly involving something like a mediator or going to an arbitrator to deal with the matter, or a referee. Your litigation plan of action. And it's important to have these ideas at the start, because if you're just taking it step by step, if you're the client, you might be incurring a lot of losses or unexpected expenses to just continue trying to keep in the game when perhaps you were not in fact prepared for what you were getting into. So it's important to have a full plan involving litigation as well. And after litigation, you need an enforcement plan. What I often find myself saying to people who are interested in pursuing someone else for something is, you need to know that that person actually has the money or the things to attach to go ahead with your enforcement of your litigation, because you might go to court and you spend, let's say, 50,000 Rand, and you get an order that you're going to get 400,000 Rand out of it. And then you go and you ask for the person you've defeated at court to pay the money. They say, I don't have the money. You go to the sheriff, you get them to attach their property. And out of the whole thing, you get 40,000 Rand. Was it worth going through the process? So it's important to have an enforcement plan from the very beginning. Then client matter and reputation management. It's important to have a plan in that sort of area, and a client budget plan including potential pitfalls. Now, if you're going against someone who is better resourced than your client is, they can try all sorts of methods to delay litigation and vice versa. So the type of, and obviously certain delays of litigation are very unethical and an attorney shouldn't engage in them, but certain other types of delays in litigation can actually bring the matter to an end via technicality, and that can be something which is quite important to pursue. But if your client doesn't have the budget for it, it might be something which is just not affordable for them. And finally, there needs to be a to-do list. It's important to always have a specific type of plan of action, and to-do lists need to have the specific people involved, any amounts which are involved, and the time in which something needs to occur. So that's the sort of general overview of the sort of topics which I plan to cover in this specific series of presentations, and it all depends on the sort of response and interest in the videos involved. My name is Marc Evan Aupiais, and nothing involved in this video should be relied upon as legal advice, or presentation should be relied upon as legal advice. For that, please make an appointment with your attorney and discuss all of the nuances of your matter with them. Thank you very much.